Okay, we're back on the record. And then Mr. Finley, you've had enough time now to have your question answered?
Yes, I have, ma'am.
And you're ready to proceed?
Yes, ma'am.
Okay, if you could verify your address for me first. I have two of them. One of them is on Terrace Street in Muskegon, and the other I have is on Penoyer in Grand Haven. Which one's right?
The one for Penoyer is my mother's address where I was at before I moved to Terrace Street in Muskegon. So
Okay,
I currently reside at the one in Muskegon.
okay, very good. And how far did you go in school, Mr. Finley?
This would have been my senior year, ma'am.
Okay, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Mr. Finley, you have the right to an attorney. You are represented by Mr. Watson. And Mr. Watson, which count or counts is this a plea to?
Your Honor, I would defer to Ms. Eisenhut as I can't seem to manage multiple screens at once.
Okay, no problem. Ms. Eisenhut, you want to give me the counts?
Thank you, Your Honor. It'll be count 2 as well as the added count 8 on the amended information.
Okay. And then, Mr. Watson, will you waive reading of the balance of the information?
Yes, we would. Thank you.
Okay, Ms. Eisenhut, then would you read count 2 and count 8?
Yes, thank you, Your Honor. This is case number 20-318 FC, People of the State of Michigan versus Jeremiah Ezekiel Nelson Finley, State of Michigan, County of Ingham. In the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about August 1st, 2019 through September 25th, 2019 at 2287 Pine Tree, Delhi Township, Ingham County, the defendant did, in count 2, persuade, induce, entice, coerce, cause, or knowingly allow a 12-year-old child to engage in a child sexually abusive activity for the purpose of producing any child sexually abusive material contrary to Michigan law. This is a Tier 2 offense under the Sex Offender Registration Act, and it is a Tier 3 offense if the defendant has a prior conviction for a Tier 2 offense. This is a felony punishable by 20 years and or $100,000. And did, in count 8, being 17 years of age or older, engage in sexual contact with a person under 13 years of age contrary to Michigan law. This is a Tier 3 offense under the Sex Offender Registration Act. Take notice that pursuant to Michigan law, upon bind over to circuit court or recorder's court, the district court judge shall order the defendant to be tested for sexually transmitted infection, hepatitis B infection, and for the presence of HIV or an antibody to HIV if the judge determines there is reason to believe the violation involves sexual penetration or exposure to a body fluid of the defendant. If the district court judge determines that testing is not required upon conviction, the court must order the defendant to be tested. This is a felony punishable by 15 years and lifetime electronic monitoring upon parole from prison, mandatory AIDS STD testing, DNA to be taken upon arrest. This done against the peace and dignity of the state of Michigan.
Mr. Finley, you're being charged here first with child sexually abusive activity. That is a felony punishable by up to 20 years in prison. And then the other count is second-degree criminal sexual conduct, a felony punishable by up to 15 years in prison. And also you will be required to comply with all the terms of the Michigan Sex Offender Registration Act, and you will be subject to lifetime electronic monitoring as well. Have you had enough time to talk about these charges with your attorney?
Yes, I have, ma'am.
And do you understand the charges against you?
Yes, I do, ma'am.
Do you have any questions about what we're doing?
I have one question, and that is about the registry, ma'am.
What's that? What's your question?
She read off a Tier 2 and then a Tier 3. I know a Tier 3 is life and a Tier 2 is up to 7 years. So upon sentencing, I'm just asking a future reference, which one would I have to do, life or for the 7 years?
I think I have to defer to the prosecutor who might know the registration requirements better than I do.
Thank you, Your
Can you
Honor.
answer?
If it were a plea to just the CSAT, it would be the 7 years, but criminal sexual conduct in the second degree requires a Tier 3 lifetime.
Okay, so I would have to do register for life then.
Yes.
Okay.
You want to go on?
I'm done talking, ma'am. I just wanted to have that cleared up.
Okay, very good. And you understand the charges, is that correct?
Yes, ma'am.
And you don't have any other questions about what we're doing?
No, ma'am. Me and my lawyer
And
had
how-
plenty of time to talk, and I fully understand.
Good. How do you want to plead?
Um, Going off the offer that was presented and was accepted by
So you
both
want-
sides.
So you want to plead guilty, is that correct?
Yes, ma'am.
Okay. If your plea of guilty is accepted by this court, it means you won't have a trial of any kind, and you'll be giving up the rights that go along with a trial. Let me go through those with you, okay? You'll be giving up a right to a trial by jury, or if you didn't want trial by jury, trial by judge. You'll also be giving up your right to be presumed innocent and to require the prosecutor to prove your guilt beyond a reasonable doubt. You'll be giving up your right to have the witnesses against you appear at a trial and to be able to cross-examine them. Also, the right to have this court order any witnesses that you might have to show up at trial. You'll be giving up your right to remain silent at trial and not to have that silence used against you, or in the alternative, if you wanted to, the right to testify at the trial. Also, when you plead guilty, you have to, if you want an appeal, you have to ask the higher court to hear your case, and they have to agree to hear it. It's not automatic. And another thing about appealing also is when someone goes to trial, if they get convicted, they can appeal pretty much everything. But when you plead guilty, it really limits the issues that you actually can appeal. So do you understand those rights?
Yes, ma'am.
And this is what you want to do, correct? Is give up these
Yes.
rights and plead guilty? Okay. Also, if I accept your plea, it means you can't come back later on and try to say that the plea was the result of some promise or threat that no one told me about today. Do you understand that?
Yes, ma'am.
It also means you cannot come back later on and try to say that it really wasn't your own choice to plead guilty today. Do you understand that?
Yes, ma'am.
Is there a plea agreement, Ms. Eisenhut?
Yes, Your Honor. On successful plea and sentence to count 2 and to an added count 8 criminal sexual conduct in the second degree, the people agree to dismiss the balance of the charged counts. Pursuant to People versus Killebrew, the parties agree that the defendant's minimum sentence shall be fixed at 84 months in the Michigan Department of Corrections.
You said fixed.
Yes, Your Honor.
Okay, is that a full and complete statement, Mr. Watson?
It is, Your Honor, but I just want to make sure that I'm using parlance that Mr. Finley understands, because we've not been talking in months, we've been talking in years, and I understand that to be a 7-year fixed maximum minimum.
That is correct, Your Honor.
So, Mr. Finley, did you hear all that?
Yes, Your Honor.
And you understand what that means? So they're agreeing that the low end of your sentence would be set at 7 years, also known as 84 months. You understand that?
Yes, Your Honor.
Okay. The maximum is set by law, of course, and I already told you those maximums, okay? And do you agree with this agreement that was made?
Yes, Your Honor, but I do have a question. I did have a deputy look up Killebrew to see what that meant. Under what he looked up, he saw that Killebrew was a max, like a cap, not a minimum. So I'm a little bit confused on that.
Okay, I'm not sure I heard all that right, but what they're saying is, as I told you, one of these offenses is punishable by up to 20 years and the other one up to 15 years. So if I follow their agreement that the minimum would be fixed at 7 years, that would mean your sentence would be 7 years to 20 years on one of them and 7 years to 15 years on the other. And of course, that would run at the same time. Does that help explain it?
A little bit, but my next question would be then, so I could get out after 7, or would I have to serve both terms?
No, you would be eligible for parole after 7.
Okay.
They run at the same time, so there's not 2 7-year sentences, there's just one, really. There's 2 sentences, but they run at the same time. So after 7 years, you would be eligible for parole.
Okay.
Got it?
Yes, ma'am.
Okay, now regarding that 7-year fixed sentence, if for some reason I decided not to go along with that, I would tell you before I sentenced you. And I would give you a chance if you wanted to take back this plea and start all over. You understand that?
Yes, ma'am.
Okay. Has anyone promised you anything else that hasn't been said right here and now in order to get you to plead guilty?
No, ma'am.
Has anyone used any threats?
No, ma'am. Other than just
Is-
making it clear the facts of the case.
Yeah, it's a tough decision, I understand that, but that's not really a threat, but I understand what you're saying.
Yeah.
So is it your own choice to plead guilty?
Yes, ma'am.
And are you doing it because you believe you are guilty of these offenses?
Yes, ma'am.
Okay, so let's talk about the child sexually abusive activity charge. And tell me what you did between the dates of August 1 and September 25, 2019.
I was talking to the victim, JC, via Facebook, sending messages, and we ended up talking, and I ended up getting provocative, and we ended up sending pictures back and forth of the provocative nature.
Okay, on Facebook? That's how you sent them back and forth?
Yes, ma'am.
Okay, and was this a child who was 12 years old at the time?
Yes, ma'am.
And I think you said a girl's name, I'm not sure, don't repeat the name, but did you know she was 12?
She told me she was 13.
Okay, but you knew
But
this
that
was a
doesn't-
minor child. Yeah, that's all that really matters, but you knew that, correct?
Yes, ma'am.
Okay, and when you say provocative, you'll have to tell me just a little bit about what kind of a picture you got her to send through Facebook. Was she naked?
Yes, ma'am.
Was she showing her genitalia?
Yes, ma'am.
So it was a sexually explicit kind of a thing, is that correct?
Yes, ma'am.
And you are the one that motivated her to do that, correct?
Yes, ma'am.
Okay, and it actually did get received on the other end by you?
Yes, ma'am.
Okay, then did you also have some contact, physical contact ultimately with this child?
Yes, ma'am, I did.
Tell me, you'll have to tell me a little bit about what kind of contact that was.
We ended up going to a park late at night, and we ended up having sexual contact with each other, ma'am.
Okay, what part of your body was in play here?
My genital area, ma'am.
Your penis?
Yes, ma'am.
Okay, and what part of her body was in play?
Her vaginal area, ma'am.
Did you touch your penis to her vagina?
Yes, ma'am.
Did you put your penis in her vagina?
Yes, ma'am.
Okay, and this is the 12-year-old, correct?
Yes, ma'am.
Okay. And did all of this happen at 2287 Pine Tree in Delhi Township, Ingham County?
Yes, ma'am. I do believe so. That is the address, but I'm not fully aware.
Okay, well, in Ingham County, I probably should have just left it at that, but has the court complied with MCR 6.302, Ms. Eisenhut?
Your Honor, just one additional question.
Sure.
Mr. Finley, were you over the age of 17 when this happened?
I just turned 18 when this happened, ma'am.
Thank
So
you.
yes.
And yes, Your Honor, you
Ah.
have.
Thank you. Mr. Watson, has the court complied?
I believe that it has, Your Honor. I believe that a fact was elicited that the victim in this case was 12 years old at the time.
Yes.
Thank you.
Are you aware of any promises, threats, or inducements other than those already placed on the record, Ms. Eisenhut?
No, Your Honor.
Mr. Watson?
No, Your Honor, thank you.
The court finds the plea is understandingly and voluntarily made without undue influence, threats, or promises of leniency. It is an accurate plea. It's supported by the testimony. The plea is accepted. Sentencing date is?
6 weeks is 10/12. That's the start of the trial.
Yeah, that's okay.
It is okay? Okay, so 2 o'clock on October 12th.
It's okay, but could we make it later just in case?
Will he still be incarcerated?
Yes.
Later than 3 or 3:45, the latest time?
3:30?
3:30, okay.
That was October
12.
12th. 13th.
Monday, isn't Monday the 12th?
Isn't Monday the holiday? Oh, no, we don't have that holiday anymore, October 12th. Okay, sorry, I had to speak with my law clerk and figure out a correct date. So, October 12th at 3:30, how does that sound for you, Mr. Watson, okay?
I'll make sure that it works out. Thank you, Your Honor.
Okay, do you want to talk with your client and see at some point and just verify that he's okay with being sentenced remotely? Because I do have to have his consent to do that.
Yes, Your Honor, I'll do that.
Okay. And Ms. Eisenhut, the date's okay for you?
Yes, thank you, Your Honor.
Okay, then, Mr. Finley, that'll be October 12th at 3:30. It'll either be the same way that we just did this plea, if you're okay with that, or else we'll bring you here in person. You will get some sort of a visit, I think probably this kind of a visit, from the probation department prior to that date. They're going to interview you. It's really important because it's for the report that I'll use for sentencing, okay? Do you have any other questions?
No, ma'am.
All right, then that will conclude our hearing. You can tell them they're at the jail, Mr. Finley, that you're all done, so they'll know that they can bring in the next person.
Okay, ma'am. Thank you.
You're welcome.